was on that corner, tryna get my coins up. Coppers run up on us and we turn to Jackie Joyner. White man kill a black man, they never report us. Black man kill a white man, they gon' start a war. Mama, she was tore up. Mama, she was tore up.
Go ahead.
Go past each of the council persons and drop off something. We're not here to disrupt. These are constituents and they are...
This is because the cops have showed up. This is Mrs. Riddick. You guys are familiar with her son.
Again, we're talking Philly. The city is zero stranger to police corruption.
Former Philadelphia District Attorney Seth Williams is sentenced to 5 years in prison after pleading guilty this summer to accepting a bribe.
But in the past few years, a wave of reform-minded district attorneys has been elected across the country.
You still have people that's inside these prisons that's not getting proper health care, that are dying inside the prison, that come from Philadelphia, that was sent there by Philadelphia district attorneys.
A civil rights organization. Criminal justice reform is one of the group's main platforms.
My name is State Senator Larry Farnese. Welcome to Pennsylvania's first senatorial district. I want to thank again Governor Wolf for bringing us all here today. I'm proud to stand here with my colleagues as part of this important conversation on the need for criminal justice reform.
You don't know how much talent is standing there on a street corner when a police car drives by. And one of the biggest things in the way of delivering opportunity to young folks in America right now is mass incarceration.
We're here to also let them know we are here for you as well as for my son Eric Riddick. I stand adjacent from the center that they call the Justice Center. It should be called the Injustice Center.
Until the philosophy which old one race superior and
good evening to you. Many are wondering what exactly is going to happen to those cases. Most of them have been continued. That essentially means they've been delayed until the new ADA assigned to the case can essentially go over the case file and prepare for trial. But Krasner, the new DA here, says he has a team of professionals working to make sure those delays are minimal.
It's a war that until they're no longer first class and second class citizens of any nation, until the color of a man's skin is of no more significance than the color of his eyes. Miss a war that until the basic human rights
Himself. He got himself to the Supreme Court. They read his briefing. They the ones who told him you have an innocent man sitting behind bars for no better reason but a poor statute. So now we gotta wait for the Supreme Court to amend the situation and release my husband. Time means nothing to them. 26 years he's been fighting this fight. 3 alibi witnesses. The scene was never investigated.
It's a war. War in the east. War in the west. War up north. War down south. War. Rumors of a war. And until that day, the African continent will not know peace. We Africans will fight, we find it necessary, and we know we shall win, as we are confident in the victory.
Injustice anywhere is a threat to justice everywhere.
is a prepaid collect call from
Riddick.
an inmate at SCI Chester. This is a call from Pennsylvania State Correctional Institution, Chester. This call is subject to recording and monitoring. To accept charges, press 1.
I greet you as I will treat you in peace. My name is Eric Riddick, also known as Brother General, and I'm a prisoner of politics. Wrongly convicted by a criminal justice system gone rogue. I'm an innocent man convicted of a crime that all of the evidence involved confirms I'm actually innocent of. Yet I have been incarcerated for 25 years and 6 months. My case is a provable case of actual innocence in which the record is saturated with all of the proof necessary for judicial redress. The criminal justice system is broken, motivated no longer by the interest of justice, but rather greed-driven motives, infected by policies that seek to mitigate the gravity of truth and justice. As a result, effective representation is no longer guaranteed. Fundamental fairness, equal protection, and due process have been systematically relegated to proxy status, and criminal trials have become mockeries of justice, nefariously producing wrongful convictions which predaciously act as the new slave ships, kidnapping fathers and mothers away from their children. As I continue to tenaciously struggle to free myself from the tightening noose of a wrongful conviction, I humbly call on the people for assistance.
As a filmmaker, I always wanted to stick close to unique stories. It's like you want that wow factor, like, damn, that's a good story. But when I first heard this story, I was pretty young, and I didn't understand then how the system was so sloppy at justice.
Put your hands behind your back, Kevin. You're under arrest. Put your hands behind your back. I'm going to take you to jail. Okay? First of all, okay, listen to me. You have none of this tear stuff. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to have an attorney present while you are questioned. If you can't afford to hire one, the court will appoint you one. Do you understand that? Say yes or no. You do.
To talk to Christine Riddick. She is a mother. Let me start with that. She's also been judge of elections here in Philadelphia for the past 20 years, and she's a advisory council member at the Francis Myers Recreation Center, and a member of the 12th Police District Advisory Board. Her late husband was a Philadelphia police officer. But the reason she is joining us today is talking about proof of innocence. Her son Eric is incarcerated right now. He spent 26 years in prison. But let me read you this. This is from an opinion, a concurring statement by a Superior Court judge, and this is what it says. No system of criminal justice is perfect. However, a system of criminal justice that prevents the correction of obvious errors is easily improved if only the legislature could see fit to do it. He is talking about the Post-Conviction Relief Act. And that is an act when evidence is not provided to the court through the, what I would say, negligence of the attorney. But the Post-Conviction Relief Act here in Pennsylvania is a very tough act, and in some cases, and certainly if it is my case or your case, a matter of grave importance to us. And so, what this judge writes is this. I write separately only to express my utmost displeasure with the Post-Conviction Relief Act's failure to facilitate justice in this case, where it is clear to all that it is likely that an innocent man sits behind bars for no better reason than a poorly conceived statute. What does that mean? Well, what the judge is saying is this is the right decision to deny the appeal under this law, but this law is poorly written, and therefore, under this law, a person who is likely innocent remains behind bars. Who we're talking about is Eric Riddick, the son of Christine Riddick. Thank you for joining us today.
Thank you, Councilman O, and good afternoon to the radio listeners. I really appreciate Councilman O giving me this opportunity to continue to bring awareness to not just my son's case, but to all those behind the walls who feel they have no voice, that there's no one outside the walls that is trying to make sure, one, those who are wrongfully convicted, that their information is put out there to those who can correct the injustice, but also for those who are looking for redemption and second chances.
Yeah, let me tell everybody, this is how I met Christine Riddick. She came to my office. She was going to different council offices in City Hall, and she's been to different legislative elected officials. Apparently, I did not know that. I wasn't there when she stopped by. I caught her on my way in. I was somewhere else, and so we didn't get a chance to talk, but we set a time to meet. But what she did is she left a booklet behind. It is a booklet of evidence that her son and her daughter-in-law and that she put together. And so basically, she set an appointment, said, please read this before we meet. I picked it up, and the first thing I did was read a concurring opinion, and it is the opinion that I just read. Wow, Justice Fitzgerald joins in this concurring statement. I mean, the thing about it is that I have never seen a judge of a court in an appeal write and say that likely an innocent man is behind bars because of a failure of a statute. Now, that is a pretty strong statement.
Yes.
And so I turned the page and I began to read about the case, and a couple things jump out at me. And I'm a former prosecutor. I've done a criminal defense as well, and so this is one of those very rare cases where not only does someone say, I'm innocent, but hands you the proof of it, the evidence of it. And so let me start with this. There was a person who was unfortunately murdered and shot, and then a eyewitness says Eric Riddick did it. He was on a balcony and he fired a weapon downwards and shot this man. The scientific evidence, the forensic evidence is that the bullets were fired horizontally or from a position upward, down to up, not up to down, right? Down to up,
and not downward,
upward and straight. So what happened? There were two different types of bullets: a 32 and a 22. And so it would indicate from the angles and everything else that two separate weapons were fired straight and from a downward to upward position, and that would contradict scientifically that someone standing above the victim would have fired downward.
Start the conversation now.
So here it is, 20 years later, and to witness this human being be stripped away from constitutional rights and freedom, all from ineffective counsel. And there's so many situations that's similar, but the city of Philadelphia just may be in position to reform history. This new DA, Larry Krasner, he said something that was very important recently on a Meek Mill special that aired on Dateline.
Krasner sent out this internal memo to his prosecutors, laying out new guidelines that many criminal justice experts have called groundbreaking.
And those guidelines are based on science rather than intuition. We all accept science in medicine. I don't know why we don't accept science in criminal justice.
So, Mr. Riddick, I got you on the phone right now. So I know you see that the criminal justice in the city is being all over the news and being all blown up and everything. Like, what's the atmosphere in the city that you in right now?
Well, in light of criminal justice reform being highlighted all over the city based off of different circumstances. You know, we got a new district attorney, Mr. Krasner, who ran a campaign on criminal justice reform, on addressing certain systemic corruption, lowering mass incarceration, etc. The atmosphere is on time with time. You know, meaning, you know, justice is in season, and justice is an idea. You know, and when an idea is in season, you know, there's nothing that can stop that idea from going forward. In this case of justice addressing injustice, that idea is being propelled by the activism of the people. You know, and my case is...
This is a call from Pennsylvania State Correctional Institution, Chester. This call is subject to recording and monitoring.
My case is in the forefront of, you know, justice being in season, because there's so much of a clear miscarriage of justice. It's so much of a clear, provable case of actual innocence. You know, my wrongful conviction is one that there is no doubt that it's a wrongful conviction. So my case is getting the media attention and the support of the people as well as politicians, because it's a case is a no-brainer. As we go into the depths of my case, you know, you will see that, again, there's no question. You have scientific evidence that's saying that I'm innocent. You have human testimony saying that I'm innocent. You have Superior Court judges and Supreme Court judges and PCRA judges saying that I'm innocent. But because of the bureaucracy of the court, a lot of the judges are saying their hands is tied in giving me the justice that you know, that is required.
Speaking of the Superior Court, from a law standpoint, you know, because, you know, me as a regular person and the people that, like the regular people, we all might think that you're innocent. But from a legal standpoint, how important is this document?
This is a call from Pennsylvania State Correctional Institution, Chester. This call is subject to recording and monitoring.
Well, first, from a legal standpoint, because it is a legal document, it's actually a concurrent statement written by not just any judge in the Superior Court, but the president judge, Judge Bender, and a former Pennsylvania Supreme Court judge, Justice Fitzgerald. You know, these are two top judges that's designated to certain cases that have significant problems as it pertains to the integrity of the conviction. So these are the judges that made this concurrent statement that we're speaking of. First, let me read. It's only a paragraph, but it's important for me to read it so that people can understand the significance of it. Basically, it says that the judges are saying that they joined the majority memorandum in its entirety. They say that they write separately only to express my utmost displeasure with the Post-Conviction Relief Act's failure to facilitate justice in this case, where it is clear to all that it is likely that an innocent man sits behind bars for no better reason than a poorly conceived statute. No system of criminal justice is perfect. However, a system of criminal justice that prevents the correction of obvious errors is easily improved if only the legislator could see fit to do it. Now, the district attorney, Krasner, has opened up a special unit in his office called the CIU unit. It stands for the Conviction Integrity Unit. And it's designed to look into cases where confidence in the integrity of that conviction is in question. There's no doubt in my case that the integrity of my conviction is in question. So much so, these judges is basically saying that I'm an innocent man, and their hands are tied because a procedure called the PCRA statute and the time limitations therefrom have become an obstruction of justice, obstructing information that can exonerate me from coming in the court and being considered. So they saying, even though we seeing the forensic evidence, we seeing the ballistic evidence, we seeing the statements and all these things that prove innocence, they saying because of the tyrannical time limitations and restrictions that's placed on introducing evidence, right? They saying that their hands is tied but we're going to make a statement so that Riddick can send to the Supreme Court, letting the Supreme Court know that we see that this man is most likely innocent, but our hands are tied because of these time restrictions. You know, so that's what's significant about that statement. I mean, this document, because this document is saying that the courts does not have faith and confidence in the integrity of this conviction. Why is that significant? Because the judicial system, American judicial system, any civilized judicial system is rooted on the very foundation of justice. Justice can never be put in a secondary position to a procedural impediment like the PCRA statute. Now, real quick, if the legislators that created the PCRA statute intentions was good, is irrelevant, because today this statute that's restricted evidence from coming in is acting as an obstruction of justice. So when that happens, you don't put the concept of justice secondary to this procedure. You put the procedure secondary to the concept of justice, because justice is the foundation upon which any civilized court system is rooted. So I hope that answers your question.
Okay. So Mr. Riddick, I'm looking at your case right now, and I see that you was accused by one witness, Mr. Stevenson, and I'm seeing that not only did he say that he witnessed you do a crime, but I'm also seeing that he came and gave a recantation of his statement. Could you elaborate on that?
Yes. Yes, Mr. Stevenson falsely accused me. I take exception with the title witness, because witness implies that he witnessed me do something, which we now know was a fabrication, even by his own admission. Like you said, he had recanted his statement, coming forward signing an affidavit stating that he lied in trial when he accused me of shooting and killing Mr. Cabot, the deceased in this case, from a balcony that's elevated 15, 20 feet above where the deceased was shot from. So again, I call him a false, an accuser who falsely accused me. Yes, it was one person, Sean Stevenson. Unfortunately, and this goes to the very foundation of this case, all responsible parties involved, the prosecution officer, the homicide detectives, the police department, everyone failed to investigate this sole accusation, right? And the gravity of law states that at the very foundation of a conviction, whether it's an authentic conviction or an unauthentic conviction, lies investigation. You know, when the police department presents an accusation to the prosecution office, the prosecution is duty bound to make sure that that accusation is authentic, and the only way that you can do that is through an investigation. So once Mr. Stevenson made his statement against me, his statement that I committed this crime from a balcony, the significance of his accusation is very important to understand. If an investigation would have been done from the beginning, then they could have debunked the credibility
This is
of
a call from Pennsylvania State Correctional Institution, Chester. This call is subject to recording and monitoring.
They could have debunked the credibility of his accusation and saved the taxpayers money, because his accusation was scientifically implausible. It couldn't have happened. If they would have did an investigation, okay, well, he accused Mr. Riddick of shooting this man from a 20-foot balcony. That means that mathematics states that the trajectory, the angles of the bullets would have traveled a certain way. If his accusation was true, it would have been corroborated by the scientific evidence, the ballistics evidence, the forensic evidence. It would have been corroborated by the trajectory. For someone that's standing above 15, 20 feet above someone shooting a rifle, then the trajectory, the angles of that bullet is going to travel downward. It's going to keep traveling downward when it hits the body, and the wound is going to have a downward trajectory. That would have confirmed his accusation. right, or debunked it. In this case, because as we go into the case, we're going to see the trajectory of the bullets. Mr. Catlett, unfortunately, was struck 5 times, 4 penetrating gunshot wounds and 1 grazing wound. Even the grazing wound left a pattern that was an upward trajectory. You know what I mean? Traveling, meaning the bullets was traveling up in the body. Now keep in mind, this accusation places me 15 to 20 feet above the deceased. So again, none of the bullets that struck Mr. Catlett, the deceased, traveled in a downward trajectory. In fact, Mr. Catlett was struck by 2 different calibers, a 32 and a 22. If someone would have
This is a call from Pennsylvania State Correctional Institution, Chester. This call is subject to recording and monitoring.
If I was accused of having a rifle that shoot multiple times, that means that the bullet, the shell casing, would have been ejected. So it would have been shell cases found in the vicinity of the balcony. But because at the very beginning of this situation, the police department, the homicide detectives, and the prosecution office failed to investigate the only accusatory theory that was presented against me, right? Those opportunities would never be presented again. They blew those opportunities, and as a result, it spun into a wrongful conviction and have incarcerated me for 27 years, almost 27 years. But let me say this on the recantation real quick. Mr. Stevenson came forward and recanted, but more importantly, during trial, he attempted not to come to court to testify to his false accusations. And when you look into the record, you will see that Paul Ribner, the judge who was presiding over the trial, actually incarcerated Mr. Stevenson to ensure that he testified. And that was his exact words. If you look into the notes of testimony, he said, well, I'm going to detain you overnight in the detention center to ensure that you testify. This is illegal. This is called testimony elicited under duress, which is testimony that lacks credibility in and of itself because of that factor. And they actually locked Mr. Stevenson up to ensure that he testified. That's first and foremost needs to be understood. Then later on, Mr. Stevenson recanted his statement and stated that he lied against me. Now, what makes this recantation powerful and important? Because as you go into the case, you're going to see that the courts allocated funds so that I can hire a ballistics expert. That ballistics expert gave a 3-page report which stated that Mr. Stevenson's testimony and accusation scientifically is fraudulent. It couldn't have happened. So this is not just an average recantation. This is a recantation backed and supported by scientific evidence stating that he lied in the first place. And lastly, on Stevenson, the Pennsylvania Supreme Court has a case called the Santana case. It's a precedent case where the Pennsylvania Supreme Court stated that when human testimony is in conflict with physical evidence, the laws of nature, and the laws of mathematics, then that human testimony should have been rejected by the fact finders from the gate. So this testimony should have been rejected from day one. But again, the PCRA statute, what it's doing is obstructing evidence like this from coming in. It's putting time restraints on evidence that can exonerate people that's wrongly incarcerated. So yes, Mr. Stevenson did recant his statement. In fact, he has become one of my, I'm not going to say my biggest supporters, but he has become one of my supporters in attempting to help rectify this wrongful conviction.
So looking at this case, and I'm seeing that you had witnesses as well, and I'm seeing that it looks like your lawyer told on his first statement of the trial that he would, bring these witnesses out, and he never did. Could you give me a little bit on that briefly?
Yes, you're speaking about the alibi witnesses.
Yes.
When Mr. Catlett was unfortunately shot and killed on 50th and Belmar, I was actually 2 blocks away on 50th and Trinity Street socializing with individuals on Trinity Street. Once I found out that I was falsely accused, I volunteered to go down the homicide division, the police department, homicide division, and talk to Detective Rich, who was investigating this particular case. And I gave a full statement explaining that I had nothing to do with this crime, and that I had alibi witnesses that would state where I was at the precise time that the incident happened. Explaining that we actually heard the gunshot, and we actually walked in that direction after the gunshot to see what was going on. He had this information. During my trial, I had 3 alibi witnesses: Justine Dawson, Tamaka Jordan, and Lewis Jordan. They all was at my trial waiting to testify. My lawyer, Dale Miller, in his opening statement to the jury, the fact finders, the jury told them 3 times, promised them that he was going to introduce 3 alibi witnesses to the state's 1 accused, right? To show that it was impossible for me to be in 2 places at one time, right? He told the jury that he was going to introduce my 3 alibi witnesses. At the end of the trial, he failed to do so. In fact, me and him had an argument before he rested his case, and I told him to present my alibi witnesses. He said he was going to do it. They got up there and said that we rest, the defense rest. At the time I didn't know the law, so, it was nothing that I thought that I could do. But he did present my alibi witness to this day, is still willing, to testify on my behalf. And yes, the affidavit, they have signed the affidavit stating that at the time of the shooting, we was on the airport socializing. In fact, Justine Dawson and Tamaka Jordan, after the incident, them being more mature than us at the time, more responsible, we began to walk up to even Trinity Street, being new, young and immature. They told us, don't go up there. We said we wanted to see what was going on, and I know that might seem irrational, but, when you're not in a mature state of mind, sometimes you do irrational things. But they actually told us, don't go up there, and this evidence never was presented to the fact finders. My lawyer committed fraud upon the court. He actually lied to the jury. And this is significant because through the whole trial, just imagine, the jury is sitting here waiting for this lawyer to keep his promise and present these alibi witnesses, and then he didn't. Come to find out also that he failed to file a legal document that's required to present alibi witnesses called the notice of alibi. It came out that he failed to failed to file this form called the notice of alibi. So he was ineffective all the way through. And let me say this on that real quick. The United States Supreme Court, it speaks about the rights that defendants have during trial. And they say the most significant right is the right to effective representation from lawyers, because it is through this right that all other rights are secured. If I'm not a lawyer and I don't know the law, right, and we have a society that provides lawyers, either appointed lawyers or paid lawyers, those lawyers have to represent the defendant from a professional, competent standpoint. When they fail to do so, all the other rights that I may have had, like I had a right to present alibi witnesses, right? That's a right that I had under due process. I had a right to cross-examination. I had a right to present exculpatory evidence. All these rights is only secured in my right to effective.
You have 1 minute left.
Effective representation is honored. Because if I don't have effective representation as a layman in law, I don't know how to present these things. I don't know how to extrapolate exculpatory evidence from witnesses. I don't know the paperwork that needs to be filed. So you can't set the deck and provide a system where lawyers, professional lawyers, is presented, right, but they incompetent. So it's as if you don't have no lawyer. What would be his logical reason for not presenting alibi witnesses? What would be his logical reason for not pulling out the exculpatory evidence in the forensic evidence that proves my innocence? There is no legitimate reason. But because I didn't receive the effectiveness that the Constitution guarantees, I've been in prison for 26 and a half years based off of ineffective assistance of counsel.
I'm looking at your timeline, and I'm seeing how active your case has been, all in the media, all over the press. What do you think that's drawing the people towards your case? And what do you think that it is that's making your case come to light like this?
Again, like I said in the beginning of this interview, justice is an idea. And again, that idea is in season. And it's very important to understand when you have an idea in season, every atom in the universe, every force that you can think of is going to propel that concept that's in season forward. Again, my case is just so repugnant. What happened to me is so repugnant to the concept of justice that it's the gravity of justice that has thrusted my case in the forefront. You know what I mean? Because there's so much of a blatant miscarriage of justice. In fact, it's beyond a miscarriage of justice. It's an abortion of justice. Because the judges, again, is admitting.
This is a call from Pennsylvania State Correctional Institution, Chester. This call is subject to recording and monitoring.
See, the concept of a miscarriage of justice implies a mistake. A mistake. When someone has a miscarriage, that's a mistake. Something went wrong in the pregnancy. A miscarriage when it comes to a child. Something went wrong. A mistake happened to something. But when you have an abortion, that's an intention. That's an intention that's outside of a mistake. So when you have judges admitting that my case is my conviction is a wrongful conviction, then now it becomes a miscarriage of justice, an intentional disregard for the concept of justice, right? And what's happening is when so many incidents happen and the people become dissatisfied, that activates their activism. You know what I mean? When the people become dissatisfied with something that's going on, then they start looking for change. They start organizing around concepts of change. They start speaking truth to power. You know what I mean? They begin to unify, on issues that they dissatisfied on. So what you see is a mass dissatisfaction, with the institutions that's supposed to represent the people, the judicial system, the police department, etc. So the people is challenging the integrity of these institutions. The people are saying, wait a minute, you have a movement that was born out of that dissatisfaction called Black Lives Matter movement. One of our biggest supporters is Mr. Alfred Khalif, who has been at the forefront of this conviction. And how this case is connected to that particular movement. First of all, I'm a black man going in front of a judicial system that sometimes don't value black life. Because if they did, then they would extend effective representation, constitutional guarantees, if my life mattered. But like Malcolm X said one time, Brother Malcolm said, lynching by any other name is still a lynching. He was saying whether it happened in the backwoods of Alabama with a noose or a tree, or you go into a courtroom, and because you're not valued, right, you judicially lynched. Because you don't have the effective representation that the Constitution guarantees. You don't have the due process that the U.S. Constitution guarantees. What you're seeing sometimes is an old relic of the past seeping up into the days expressions of the court system. It's just more systemic. It's just more cleaned up. It's bloody, but it's no less deadly. It's no less deadly. One may say, well, you can't compare this lynching to that type of lynching. Well, you tell that to somebody that's sitting in a cell for 27 years that's the size of a closet. You know what I mean? You have that argument with that individual, and they'll tell you that it's just as lethal as putting them in the oven, like over in Germany, or lynching somebody from a noose. In fact, it may be worse because it's a perpetual. Every morning you waking up lynched until that injustice is rectified. So again, the people are dissatisfied with the way that these institutions is functioning. My case, my family, I thank the Creator that I have family and friends and supporters that see the value in my struggle, see me worthy of their activism, So again, my case is getting the attention that it's getting, I believe, because it's on time with time, and it's, again, We have the materials. We have the materials to prove what we think. You know, and you just look at the PCRA statute, for example, like we spoke about Councilman O. You know, the last rally that we had in front of City Hall, my family and supporters went up to the city councilman's office and gave out pamphlets that we had put together that's explaining this miscarriage of justice from A to Z. This compelled a Republican named Councilman O. It compelled him to set up a meeting with my family in regards to my case. You know, in light of that, in the aftermath of that meeting, and in the aftermath of him reading my case, he pledged his support regarding my case. He spoke to his Republican constituents and urged them to stand with him on calling for the immediate exoneration and freedom of me based on the clear evidence of actual innocence. But here's the significance with Councilman O. He's also a lawyer. Him and the Democrat Joanna McClinton, who is also one of my stark supporters. But they are lawyers, so they understand that at the foundation of our judicial system is a concept that explains that any time you have a doubt that a conviction is authentic, then just that slight doubt requires the court to give a new trial to that individual because they cannot risk having an innocent man in prison. You know what I'm saying? So in my case, there's not a slight doubt that I'm innocent. We have judges from all sectors of our court system, the PCRA judge, Judge Cooperman, who stated that the ballistic evidence in my case is more likely exculpatory. That's in the record. We have a Superior Court judge, not just any Superior Court judge, but the President judge, in a concurrent statement with a former justice, Pennsylvania Supreme Court judge, stated that the PCRA Act failed to facilitate justice in this case, where it is likely, where it is clear to all that it is likely that an innocent man sits behind bars. When you have these elements openly saying this, the only response is either immediate exoneration or at least a new trial, right? So that a process can be put in place to either reestablish confidence in his conviction through a new trial or immediate release and exoneration. To allow a process to continue after it is acknowledged that this man is innocent and this man have already been incarcerated under the nefarious cloak of a wrongful conviction for 2 decades plus is a mockery in and of itself. And this is what upsets the people. This is what is compelling the Daily News and the Inquirer to write stories regarding this case, because you can't. It's no longer. There's nothing else to hold on to, in regards to this case, So I will urge the prosecution office. And remember that the DA office always retain the right to withdraw any further persecution or prosecution of a conviction if they don't have confidence in the integrity of that conviction. So this is why we have advocated in front of the DA's office, and the people right now is putting out the rally call because we're going back in front of the DA's office. And my case is unique because we have the evidence, but my case is not unique in that there's no other cases. There are many cases of individuals sitting in prison, wrongly convicted, that don't have the support that I've been blessed to receive. But Councilman O went further. Once he introduced my case to the city council last week, this next week at the city council session, he introduced a resolution to the city council that was wholly accepted by the president of that assembly as well as his constituents, stating that there's a need to amend the PCRA statute to allow evidence that
you have 1 minute left
that can prove innocence, right? To allow that type of evidence to overcome any time bar. And let me say this: there's no statute of limitation or time bar on the state bringing up charges on somebody that committed a murder. So if someone committed a murder in 1970, they can charge you in 2000 18 with their crime. There's no time limitation. So it's hypocrisy to try to put time limitation on people that's incarcerated for murder if they have evidence that can prove their innocence.
I'm looking over your case, and another thing that's like I'm looking over that's heavy. Your support letters. Now I see you got some support letters from different people, and even got it from the Department of the Army. Could you touch base on that?
Well, let me say this. Those letters that I had from those individuals that was in the military, that served in the military, United States military, is significant because if you look at those support letters, this organization, well, development organization, is an organization of veterans who took an oath of office to defend the United States Constitution against any threat, foreign or domestic. And they have concluded, since they have come off of these tours of duty, going all around the world, fighting for justice for other people in other countries, right, in the interest of the United States. They came home and they realized
Pennsylvania State Correctional Institution, Chester. This call is subject to recording and monitoring.
They realized that justice has been denied, is being denied to citizens right here in the so-called democratic borders of America. And being though they swore to uphold and defend the United States Constitution against any threat, foreign or domestic, their conclusion, and when they looked into my case, they said that wrongful convictions is a threat to the United States Constitution that they swore to uphold and defend. So their support in my case is an extension of their military duty to defend the United States Constitution, because they saying that wrongful convictions, because the United States Constitution states that I'm supposed to have a fair trial, that I'm supposed to receive due process, that I'm supposed to have effective representation. All these things come out of the United States Constitution. These are guarantees. So when a citizen of the United States is deprived of those constitutional guarantees, that's a declaration of war in any soldier mind that swore to uphold and defend the United States Constitution. So if a wrongful conviction has come out of those deprivations, then those same soldiers that soldiered on foreign lands to secure justice is now standing against wrongful convictions, specifically in my case. They have signed support letters speaking to the powers that be, the same ones that have sent them across seas to fight for justice in other foreign countries. They saying, well, this is an extension of our military duty, because it's a threat to the United States Constitution, and therefore we stand against the wrongful conviction of Eric Riddick. So that's the significance of those support letters, and those individuals explain in their support letters that, listen, we actually called on the powers that be to rectify this. Until then, we on the front line once again, fighting for the lootable concept of justice right here in the democratic borders of America.